Okay, we're on. This is ThinkTech Hawaii broadcasting on a Wednesday. This is actually the time for Donna Blanchard, she's French, Donna Blanchard, who has a show called Arts in Hawaii, The Arts in Hawaii. So if it's okay with my guest, Avi Soifer, we'll call this The Arts in Hawaii. Maybe it's an art of some kind.
And not a science, for sure.
Not a science, right. It's about constitutional law. And Avi Soifer is the dean of the William S. Richardson School of Law. He's a product of the East Coast academic establishment. He has a resume which is underneath my papers over here. And if I started with the resume, it would take the whole show.
That sounds like it's worth doing. That's good.
And that's only the stuff he's written, much less the schooling.
You keep it buried. Keep that resume buried.
You better watch out or else I'll start reading from it. Anyway, that's Avi Soifer, a dear friend and a wonderful dean of a wonderful law school, the William S. Richardson School of Law, and a constitutional lawyer from Yale, which is really important. And today we're going to talk about data surveillance. It seems very relevant these days with the Snowden affair. And we call it data surveillance, how now the Constitution? Because after all, it's all about the Constitution. And our Constitution is so precious to us. It is the core, the backbone of the country. And that's why it's important to talk to a constitutional lawyer about what's going on and get our bearings.
Good to be here, Jay.
Thank you. Thank you for being here. Okay, so anyway, let's talk first about you and constitutional law. Tell us the nexus.
Why I'm interested in constitutional law? Because it's the backbone, and what else did you say of the country? Constitutional law is endlessly fascinating. For one thing, it changes all the time. There are those who think it's all written down at a time of the framers. No one's quite clear who the framers were, so that in itself is controversial. I'm interested in history, and so the intersection of this very important and ever-changing area of law with its historical context makes it very exciting. I don't know if my students are excited, but I find it very exciting.
So you've been teaching constitutional law for a long time.
Decades and decades, yes, indeed.
After a while, you really get good at it, too, I understand.
We'll see. The returns are not in.
Well, you know, I had Norman Dawson. Did you ever know of him?
Oh, yeah,
He was the NYU constitutional law fellow, and he would pace when he taught. And the floor
I think Norman
shake.
Dawson is still around, and he's quite a distinguished character.
Yeah.
Yeah.
He was great. He was so exciting, and you could never follow exactly what he was saying. But,
well, that's another nice thing about constitutional law.
That's like constitutional law it's hard, isn't it?
Well, it's hard because there are many layers, and because it really does get to the essence of our political system and the constraints under which both the political system and individuals function. But a lot of it has to do with the public and the public's perception. So there's recent scholarship and other discussion about the popular constitution. What do the people think, and how much should that matter? There's an ongoing question about whether the Supreme Court of the United States should reflect what the people think, or try to be out in front of them, or actually wait to see what the so-called democratic branches, or more democratic branches, have to say on a particular question.
Is that a new question,
It's
new
an
study, or an old study?
It's a very old.
So where does it tilt? Does it tilt toward following what the people would like to see, or what they would like to see?
I think one of the things that makes constitutional law so interesting is that there's inconsistency among the justices, and there's inconsistency over time. It's very hard to say this is the principle. There are a lot of things that are in play in a leading constitutional case. So you have the question of the relationship of the nation and the states, for example. You have individual, community, government. And then there are particular texts within the Constitution that have something to do with it and have a lot to frame the discussion, but probably don't resolve the discussion, Justice Scalia notwithstanding.
Well, it seems to be everything rolled into one, you know? It's the most, in my view, maybe you'll agree, it's the most important area that the Supreme Court covers, because it really defines the country.
Right, I think that's right. Although one of the things that we don't do enough in studying or talking about is state constitutions, because states have their own constitutions, and the state Supreme Courts, or whatever the High Court is called, have authority to go beyond what the federal Constitution says in protecting rights, for example.
They can be tougher.
They can be tougher on the government and less tough on individuals. They can't be tougher on individuals if there are individual rights at stake.
Right. Wow.
So they can add, it's called a ratchet theory by some, so they can add to rights. So for example, if the Fourth Amendment is held to allow a certain kind of search as a federal matter, a state court can say, we're not going to allow that search. Our state constitution protects individuals beyond where the federal courts go.
It's a great thing. Federalism's a great thing.
It is. But then you have the relationship of the branches. And how much deference is the legislature accorded either by the Constitution or by tradition? You have judges who sometimes say, well, we could decide this case, but we won't for prudential reasons. Then we argue about whether they were right or wrong. To be passive, they're called the passive virtues by some. But the activist label is one that I think is a misnomer almost all the time, because those so-called conservatives are often very activist, just as they turn around and accuse other people of being activists. So what does it mean to be an activist judge? You might be protecting First Amendment rights, or you might be protecting the power of Congress or the power of the executive. So the label activism has great political traction, I think, but actually is a misnomer.
Am I right to say, I mean, you're familiar with the whole legal educational system, is that constitutional is a required course in most law schools?
I would say probably in all law schools in the United States. Yeah.
And that actually makes a lawyer, that he can understand the country at that level. We want our lawyers to be constitutional lawyers. We want them to understand. We want them to abide by the Constitution. It's like taking an oath, isn't it?
Well, we try in constitutional law. I don't know that understanding follows from a required course necessarily, but no. And I think it's important for the general public to understand the Constitution as well. One of the things that's a little frustrating is that you get a Supreme Court decision, and then there's immediate polling done by a TV station, let's say. What did you think of today's decision? There's not even a pretense that anyone has read it. But then they'll report 62% of the public approve or disapprove. Well, one ought to at least read what is written about these very important and sometimes very difficult constitutional questions. And one of the best things about the Supreme Court is that, unlike other people in Washington, they really do try to explain what they're doing. There is a tradition not just of a majority opinion, but of someone who might agree but for other reasons, and of course dissenting opinions. So there is at least the effort to write, which is difficult, but sometimes illuminating, not always, but sometimes illuminating, and to explain your reasons. Now, a cynic might say, yeah, that's not really why they decided, it's what they had for breakfast, was what they used to say.
It could be.
And it could be what they have for breakfast, but at least you then have what they claim to be the reason, and you can use that as you build the next case, or another judge might use it. Sometimes it's the author of that phrase, or that sentence, or that interpretation.
What interests me about the Supreme Court, too, is that it can change its mind. That one court can override what another previous court did, and they can have it on breakfast if that's what they want. And you can't necessarily predict, but there are people who can make pretty good predictions, too.
Oh, I think that's not so hard much of the time. But when the court decides to reverse itself, it is usually important. But it's interesting that the sort of black letter law, as is said among lawyers, the law that's written down clearly, says that precedent is less binding in constitutional law than in other areas. And the reason for that is in other areas, the legislature or the executive, the legislature can change things. So you interpreted our statute a certain way, well, that's not the way we want it, or that's not the way we meant it, here's what we meant. With the Constitution, it's only the Supreme Court that gets to correct its errors. And so they're actually supposed to be freer to reverse an earlier decision if they now think it was wrong.
What a great system, honestly, that the Supreme Court can do that. It stewards the essential, word on which the country was created. Isn't that amazing? And it's alive and well and happening, and presumably faithful to, history and faithful to where the world in general is going. What an exciting topic, I hope you guys realize how exciting this topic is. This is really exciting. You should study this. You should read the decision.
You should come to law school.
Yes, come to law school.
Right.
Dean, it's the dean.
And we have an evening program. I'm teaching constitutional law in the evening, starting in late August.
Public.
Yes.
Oh, that's great.
No, not for the general public, but people could talk to me and sit in if they want.
Okay. Okay, well, with that background, it's really important that we, all of us, understand and get involved and make this part of our thought process, because we're all responsible. And if everybody, takes a powder on this, the country is at great risk. We really have to be involved. We have to be connected on the way the Constitution unfolds. So here we are faced through Mr. Snowden with a huge constitutional issue. The guy goes out and he says he's a whistleblower. He says he's doing us all a favor, but he's compromising national security big time. He's compromising the government big time. And, you know, he was hired, this is my view, he was hired for the national defense, for the national security. That was his job. And he turns on his own employer, he turns on the country that hired him, and he does the country damage. Whatever his reasons, that's the basic syllogism of what happened. So I mean, there are some people who think, you know, he's a traitor, and that's that. And I guess the administration would like to see him out of circulation. and if I
And he is out of circulation. He's in the transit lounge.
He's still in the transit lounge, learning Russian.
Right. But you're assuming a couple of things, Jay, about national security, and it's a very murky area as to how much national security has been endangered. And it has been a murky area for a long, long time. Before we are too quick to say, oh yes, the government says so, it must be so, we have to reflect on what happened in the 50s in McCarthyism. And during that time, the government was certainly saying that membership in groups and certain kinds of speech and certain areas of discourse were a threat to national security. And they were costing jobs and otherwise rounding up and punishing people they believed at the time to be real threats.
Why does this sound like something I could find in a book that was recently published? It was called Law and the Company We Keep. And it was written by, I think it was written by you, and it was published by the Harvard University Press.
I don't know.
Is this a true fact?
There's only a little in that book, but thanks for the plug. So the Pentagon Papers is one of the precedents that is going to be important, is important as we discuss this. And people may not remember that in the Pentagon Papers case, the government, the Nixon administration, said that publishing a history of the Vietnam War was going to endanger national security. Daniel Ellsberg and others did not believe so, and neither did the New York Times, or at least if it did, it balanced the public's right to know as more important. There's an interesting little story about what happened first in the Pentagon Papers litigation. There's a new federal judge. He was a Nixon appointee. It was his first case. He'd been on the bench for a month or 6 weeks at the most. And he was inclined towards the Nixon administration, which had just appointed him after all. And there is some politics related to constitutional law once in a while.
What was his name?
It starts with a G.
Italian name, as I recall.
Yeah.
Yeah, I remember that because it was such a big deal at the time.
So he said, well, he let it be known that he was inclined towards the government, as judges sometimes do, but he said, you know, I want to know what the danger to national security might be. And they said, okay, we'll get you an expert. So they bring up the expert from Washington, and they go into chambers, so there's no public scrutiny of what's going on. And the judge says, okay, here we are, nobody's listening, tell me what's going on, tell me what the danger is. And the expert from Washington says, I could tell you, but I can't. This does not please the judge. And so the judge, and then it's, yeah, if you can't tell me, who can, right. So that's an issue as to, we leave these things to judges. They don't really have expertise. What are they supposed to look at as evidence? How much evidence? Are they supposed to call in experts? Anyway, what happened in that case was the facts outran the litigation because newspaper people started picking it up and publishing it. Was it a danger to the nation? Probably at the margin, in some small way, yes. There were some things disclosed, often unknowingly, between the lines, as it were. Yeah. But it was also very important for the American people to understand how we got into the mess that was the Vietnam War.
And it was a mess, for sure.
And it was certainly a mess. So that's a leading precedent that says there is some freedom of the press. There are other precedents, including a case I was involved in, which was the Progressive Magazine case, and this was 1979, where the government successfully enjoined publication. So a prior restraint is very much disfavored in First Amendment law. That's kind of the ultimate no-no, that you can't stop publication. You might punish afterwards, but you can't stop it in advance. That's what prior restraint means. Federal judge issued a prior restraint that actually stuck for over 4 months. Now, again, the facts outran, the publications outran the injunction. But the danger, this judge thought, was that it was more likely than not, he used what's called the bad tendency test, that the hydrogen bomb secret would be revealed. Perhaps there was no secret, but that this would help the Pakistanis, that's who was being worried about at the time, get access to atomic weapons sooner than they otherwise would. And one of the things about being involved in that case was to find out, some of us had clearance and others didn't, that the government's position, and this was the Carter administration, was that there are ideas that are born classified. So that if you don't have adequate clearance, even if it's your idea, you can't retrieve it. Furthermore,
Actually, you shouldn't have had the idea in the first place.
there's no procedure. The idea, and they put this in their briefs, is born classified. So it's classified once it comes forth as an idea. Well, once you do that, and there's no procedure, then everything is classified, arguably, and then nothing. There's so much classified. There are so many people who have clearance. And one thing you said in setting up my long discourse that I think needs a little asterisk, which is he was not employed by the government. He was employed by a private company with a contract with the government. So our security state
Has changed.
And it's not just the government any longer. And there are, of course, people interested in a pocketbook way as well as in an intellectual way in what passes for national security.
When I was in the service, this is 30, 40 years ago, very few people had high security clearances, very few. I didn't. And most of the people I worked with didn't.
Well, you didn't, it goes without saying, Jay.
That's clear enough, and the reasons are clear. But you know, now there's something in the order of 1.5 million people in this country by contractor or in active duty who have security clearances, and that has also changed. But I want to be clear, nobody in this room has a top secret clearance. So what we talk about here is not classified. That's Avi Soifer. He's a dean of the William S. Richardson Law School. He's a constitutional scholar. We're talking about data surveillance, how now the Constitution. We're going to take this little break. We'll be right back. Okay, we're back. We're live. This is Jay Fidell. It's ThinkTech. We're talking about the arts in Hawaii today instead of Donna Blanchard, who is traveling on vacation. And we're with the Dean of the William S. Richardson School of Law, Avi Soifer, and we're talking about data surveillance, how now the Constitution seems only appropriate since Avi is a constitutional scholar. And we left the point before that there are 1.5 million people in this country who have security clearances, and that is really a remarkable number of people. And I guess the question is, how does that affect things? Because you can't possibly keep control of all those people. I mean, if 27,000 people wanted to do what Snowden did, we'd really have a problem.
Mm-hmm.
I mean, just structurally.
Right, and even if you didn't have classified as a mechanism for making things secret, if there are just people stamping secret every piece of paper that comes by, then there are so many things that are secret that, in a way, nothing is secret.
Yeah, yeah.
So that's a real problem. And Senator Moynihan had a report. Obviously, it's a while now since he's been dead for a while, but and he really said you got to declassify. I mean, the real problem is overclassification.
Right, because then you sort of you waste it. It has no value after a while. But something you said before the break, which I'd like to dwell on for a minute, is it sort of depends, as it did in the McCarthy time, on exactly whether you are damaging national security. If you assume that the damage is marginal, as it was in the Pentagon Papers, then you're really violating somebody's rights to shut him up. But if let me offer a factual change on you. Let's say that in the Snowden papers there is stuff there that would damage the United States. I don't know if that's really true. It may not be true, but they seem to say that's the case. So what then? Does that change the way the law applies? Does that make him more of a traitor? Does that make the Patriot Act or whatever act would call him a traitor? I guess it's not the Patriot Act. It would be the
Espionage Act.
The Espionage Act.
Right.
Does that make it more likely that he has violated that, and be less likely if there were less national security in what he revealed?
Well, I think you, yet again, Jay, have put your finger on something important. And what is your finger doing there? No. It's really almost always, and maybe even always, a balancing test that a court's going to apply. Now, there are different ways in which they weigh things as they do a balancing test, but there really are not absolutes. There are not absolutes even when you start with the preamble of the Constitution, which is about domestic tranquility and security and liberty all together in the preamble. So which one is it? How do you weigh them? And the Constitution doesn't answer that question. It doesn't say the tiebreaker goes to. So Hugo Black used to like to say that the First Amendment is absolute because it says Congress shall make no law. But then affecting, limiting speech, freedom of expression. What's expression? Is it only verbal and written? What about a symbolic armband? Is that expression? He said no, by the way. He was an absolutist, but he didn't think an armband counted as expression. So even defining what is speech is difficult. And even the constraint that says you shouldn't have prior restraints doesn't say never have prior restraints. It says if you're going to reveal the location of troop ships, we can stop you, because that's a danger. So even those who are vehement about the importance of the First Amendment generally concede there are some limits. There are some things that can't be said. The classic statement of that, of course, is Justice Holmes talking about shouting fire in a crowded theater and causing a riot. People often forget that last part. And what if there is a fire? Well, obviously, then it's okay to shout fire, at least if you do it without causing a riot. So even that famous bit of language doesn't answer the question about, well, when should you tell people around you that there's fire? So this is not an absolute. And on the other side, national security is too easily invoked. It could be that jobs for Americans are related to national security. So someone who sells bonds to the Chinese might actually be affecting national security. When do you say, yeah, that really counts as a danger to national security?
So it's not a science, it's an art.
Exactly so.
That's why it's here on Arts in Hawaii. But to me that's okay. I'll tell you why. because the job is not really the specific case. Although the specific case could be very, very important. It's the fact that you are articulating a principle or re-articulating a principle. You're articulating boundaries, and people don't necessarily know exactly where the boundary is, but they know the principle. And so you don't want those 27,000 people all revealing classified information. So it's okay not to have a specific, hard line. Just to remind people that there is a possibility that if their case comes up to the Supreme Court, they may get nailed.
Right, and having said it was a balance, it doesn't mean that, well, you just throw up your hands and say, well, it's whatever you want. You have to try to analyze what counts in that balance. But the principle is one that has to be flexible, I think. It can't be an absolute principle on either side. Now, there are some who don't believe that, and Justice Scalia is a good example. Maybe for the need, some people want clear lines and want clear answers. That may be a psychological motivation or whatever. But I think to do constitutional law, one of the things that makes it exciting is you're writing not just for this decision, as you suggested, but you're writing for the future. That's one of the reasons that dissents are published. You lost, you didn't have the votes, but you're writing a dissent to try to persuade people in the future that the majority didn't get it right.
Just a digressionary point, a footnote. We were talking before the show began about Jack Balkin, who was teaching Yale Law School, constitutional law at Yale Law School. And he was here on HBR. I think you put me in touch with him because he's a friend of yours,
yes,
right? And he came, we had a wonderful discussion, and I asked him in the course of that conversation 10 years ago, I was concerned about what George W. Bush was doing to the Constitution, both in his appointments and in his executive
And you were
decisions.
young and bright-eyed in those days.
I was young and bright-eyed.
Right.
Well, some people stay young and bright-eyed. It's a mental thing. Anyway, so I asked him, I said, if George Bush, as I think, has, sort of undone the purity of the Bill of Rights and human rights and civil rights in this country, can we go back when he's finished, when he's out of office, so we can be able to snap right back and continue the great trajectory that was established by the Supreme Court in the 100 years before George W. Bush? And he said no. He said it's history, and history has its twists and turns, and it will never be the same as it would have been without him.
Right. And I think Jack is a very good constitutional law scholar, and he emphasizes context. But when we talk about history, we have to remember that it isn't a straight line. And the court has a lot to do with that, but history in general, of course, is not a straight line. So the Espionage Act that we were talking about before comes out of the World War I period, which was an awful period for civil rights and civil liberties. So should that count against the Espionage Act now, that it came out of xenophobia and it came out of a time when anything German had to have a new name? So sauerkraut became Liberty cabbage, and people literally were being hung on occasion for saying something that was thought to be unpatriotic. We don't want to go back to that, and yet that's where the Espionage Act comes from.
Why does this remind me of the Jones Act? The Jones Act was adopted for reasons that were locked in post-war, post-World War I protectionism, and it actually was a matter of lobbying by certain interest groups more than any grand principle, and yet it still governs the way this state operates, even though the way it operates has nothing to do with the reasons that law was adopted in the first place.
The 1920s were a time when state after state tried to forbid the teaching of anything but English. And actually the Supreme Court stepped in an activist way and struck down those laws, but they were aimed at teaching German, and there's a Hawaii case about teaching Japanese that went to the Supreme Court. Actually, they didn't decide it on the merits, but they tried to ban teaching Japanese in the territory of Hawaii.
This is so interesting. I want to come and see your class.
Please do.
And so after the break, we'll take a break now, but after the break, I'd like to come back and talk about the Patriot Act. The first one and the second one really all the same, how they came about and how they affected the country. And certainly they were part of my question to Jack Balkin. How could this have happened to us? How could these little black boxes be all over our internet traffic and telephone calls. But for now, on the cusp of that question, we're going to take a break. This is Jay Fidell on ThinkTech. We're doing the arts in Hawaii with Avi Soifer, the dean of the William S. Richardson School of Law, great dean in a great school. We're talking about data surveillance, how now the Constitution. We'll be right back. We're back, we're live, we're ThinkTech with Avi Soifer, the dean of the William S. Richardson School of Law. And we're talking about data surveillance, how now the Constitution. One of the things that concerned me, not that I was ever, Norman Dorton, my teacher at NYU Law School, boy, he was way ahead of me by miles, so were you. And I could never follow it, but it really bothered me when I saw the Patriot Act. I thought, oh boy, this is an act for the time following 9/11. There was, in my view, then and now, was an overreaction, and all of a sudden we lost the right of privacy, and the government was all over everything we did. There was no more Walden Pond for us. And it troubled me. Did it trouble you?
Yes, it did. Although, given what we've been talking about, it is understandable after 9/11.
I think I'm going to turn that off.
I think you're being listened to, actually.
Could be.
That's how they don't tell you. After 9/11, there was obviously great concern in the country for enemies who previously had not been known and who still were very shadowy and a time of great fear. But they did lead to great assaults on privacy, to guilt by association, including rounding up people, and clearly some restrictions on First Amendment and privacy matters. Now, it's important to know, and this gets back to the constitutional text, that there is no privacy right mentioned in the Constitution. Privacy as a constitutional matter is a construct by the court.
Interesting.
The state constitution actually does have an explicit privacy
So
right.
the state is ahead in this case.
One could say so. So if you don't like activist judges, then what do you say about the fact that it is judges who have created privacy as a constitutional right? Now, I think the counter to that would be people saying, well, it's just basic, it's one of our natural rights or something like that. But once you start down the path of natural rights, you're moving away from the text, and you are actually validating, letting the judges or somebody else define what those rights are. Freedom of association is a related matter. The Constitution doesn't actually say freedom of association. It's derived from the First Amendment, and it is tied most specifically to the right of the people to assemble for redress of grievances. But that doesn't talk about freedom of association, particularly not private freedom of association. So these rights, I'm not denying.
This would be in the book called Law and the Company We Keep by Harvard University Press, written by.
There is some of that in there.
Thank you.
Those rights are important rights, but they're not gotcha rights. And I think the Tea Party people in particular think that the rights that they think are really important are in the Constitution without actually consulting the Constitution.
Isn't that interesting? So we have a document that breathes or allows for, I mean, so far it has allowed for a right of privacy that was not written into it by implication, I guess.
Right.
And the Tea Party would like to see that because they're kind of libertarian about this.
They believe there's a big right to
The
privacy,
government should
and
leave
yet
me alone completely.
but it's not in the Constitution.
Yeah.
Now, you say leave me alone. So Justice Brandeis was a very wise person, one of our great justices. I think most people would agree. And he's the one who talked about the right to be let alone. And Justice Brandeis wrote an article with an upper crust friend of his. He was a very successful lawyer in Boston, about privacy. So that's in some ways where you can trace it back to that article. They were arguing about the press, the yellow press, that was going too far in revealing what socialites were up to. So they were trying to protect the privacy of the upper crust. So the same justice who talked about the right to be let alone, not left alone, let alone in a dissent, also talked about sunshine being the best disinfectant. So which way is it? And they're both important. We do want transparency, that's the sunshine part, and we want privacy. And where's the dividing line?
At breakfast. That's where it is.
Right.
Well, before too much time goes by, I would like to raise the Electronic Frontier Foundation case, which is only a week or two old. And I guess it was a natural outgrowth of the whole affair, the public spectacular about Snowden, which is still going on, where a bunch of really unlikely bedfellows got together and filed this multiple-party suit against the National Security Agency, NSA, to stop them from doing all the stuff they do under the Patriot Acts. Can you tell us a little about that?
The gist of the lawsuit, as I understand it, and I haven't been following it closely, is a freedom of association claim. And the claim is that the government is able to intrude, find out who I've been calling just by looking at the record of my phone calls. It intrudes on my ability to associate with whomever I want to associate with. If they can start finding out that I've associated with so-and-so, there is guilt by association that's likely to follow. You're right about the strange bedfellows. It's said that politics makes strange bedfellows, but the quote, actually, the original, is from The Tempest, and it's misery makes strange bedfellows. But the strange bedfellows here are gun owners associations, Unitarian churches, liberty groups. I don't know that the ACLU itself is involved, so it's a really strange group. So there's a freedom of association aspect just to who the plaintiffs are in this weird amalgam of plaintiffs.
Well, it's been said, that this is a violation somehow of the Fourth Amendment. I don't know if that's in the case. But, what about search and seizure? These guys, under the Patriot Act, and I don't think anybody raised it at the time. I don't think the ACLU, I think they might have been sleeping at the proverbial switch at the time. These guys were NSA or others. It wasn't only NSA. In fact, I think NSA is a late comer on this. They were planting black boxes in internet provider offices, like down the street here in Honolulu. And those black boxes could listen, at discretion to anything that passed on the email. Well, that's really incredible that they could do this essentially without a search warrant. And I mean, in the classical sense, a search warrant, where you go to court, you talk to a judge, you find him at home, he signs a paper, and then the police go out. You see it on Law and Order every day, 100 times.
Old-fashioned.
Well, maybe 10 times.
But
anyway.
they don't need those boxes anymore. They can just get it out of the ether now, right?
That's true.
Right. So see how far we've come.
That's true.
So there was an early 1970s case that said that you couldn't have domestic surveillance, but it sort of allowed foreign surveillance. And we have the special FISA Court, which has not always agreed with the presentation to them, but 99.9 something % of the time they've allowed it, and that's troublesome in itself. Just that record would make us suspicious of any other court, and I think should make us suspicious of this court. But what compounds that is that it's not an adversary proceeding. It's only one side. And again, it gets back to what are the judges supposed to do except take the government's word for it, particularly if there's no adversary who's pointing out that there may be holes or it may be not timely or whatever it is. And now we find out that even though there's been congressional testimony denying it recently, that there is domestic as well as foreign surveillance, that barrier doesn't exist.
Seems clear. Yeah.
From a technological standpoint. Yeah. Now, arguably it doesn't exist with the internet, but the courts haven't decided that. The government and the FISA Court apparently did decide it, but what we've just had disclosed appears to be going beyond the FISA Court. Even though that looks like a rubber stamp, that wasn't enough. The surveillance has gone deeper or further than even the special court.
We don't know, but we know they're spending a lot of money. And every time I have gotten close to the issue by talking to somebody who might know somebody who knows something, the answer is something like, you wouldn't believe it, what they do. I believe it, I believe it.
And Hawaii has figured in a number of these recent cases, and if they do get Snowden, Hawaii is one of the places that might have jurisdiction.
That'll be interesting. What a trial.
The place that he was most recently in.
Make Dee Dee look like a piker. But you know, the whole secret court thing, it was a construct. It was an invention, sort of like a tech invention, unprecedented and of questionable constitutionality, I think. You know, with one party talking to a judge. After 9/11, it was all driven after 9/11 in the Bush administration, and they went to, as I suppose they might have, you know, you would assume they would. They went to technology. It's all about technology. All the surveillance is about technology. And by the way, at the same time, and you and my brother, and Ed Burke together about, what, a year and a half, 2 years ago at this table, you talked about Guantanamo, which is a big deal because Guantanamo is also a construct, unprecedented, out of nowhere. I mean, you could argue something out of the Civil War, maybe, but it really was, strange and surprising.
Your brother is the real expert on this, but you're absolutely right, and Guantanamo is one of those, and related cases, one of those areas where I think we can be proud of the court for having stood up somewhat to the administration and to Congress. It wasn't just the executive. So Congress tried to take away jurisdiction, and the court said, no, you can't do that, even though you've been clear in trying to take away habeas corpus jurisdiction. So the court, even the conservative court, as this unquestionably is, does stand up sometimes for what we like to think of as the rule of law and constitutional values. The FISA Court, by analogy, one could say, well, it's like a grand jury proceeding, or like applying for a warrant in a Law and Order every show kind of way, because the defense, of course, doesn't get to come in either to the grand jury or to the warrant application, but ultimately the defense does get to challenge it. And they can say, wait a minute, that's not consistent with what you said, or you were looking for X and you got Y, and this way, nobody gets to challenge it. There's no review. So it's not just the way the procedure works, it's then it just goes off into the ether.
Yeah. Well, you know what's interesting, I mean, I think I saw this in the Times recently. Somebody raised the question of whether what the FISA Court was doing was precedent. You know, take a certain, you know, set of facts about whether they could go and put a box here, there, whatever they were doing, and eavesdropping on this person or that. And somehow what they were doing, those orders, if they get revealed, I don't know if they are, later, could be precedents. They have precedent coming out of a secret court. How about that? Is that like the Spanish Inquisition or worse?
I wasn't expecting the Spanish Inquisition, but it does certainly sound like the Star Chamber in Anglo-American history. And there's an additional way in which it doesn't look like precedent, which is they're not apparently writing it down. Plus, the judges are in secret serving and then rotating off. So it's the review, which is part of establishing a precedent, doesn't seem to be present there. On the other hand, people do tend to want to repeat their patterns. We all do. Maybe lawyers more than most.
Sure.
So you have a template, and then you're likely to follow it. So in that sense, in a real sense, yes, I think it's a precedent. And if they just decided something last week, they're likely to decide the same way today because they want to be consistent.
That's scary. It's also, you know.
I'm here to scare you, Jay.
You are scaring me, and you know, how are we going to deal with it? Look how hard it was for the administration to get rid of Guantanamo, and it hasn't really succeeded yet either. After years of promises about that, and how much trouble is it going to be to get rid of the FISA Court as a concept, not just the FISA Court, but some other court. This is how George Orwell in Big Brother, you know.
Speaking of your brother, he's going to be here in March. He's going to be here in March, and we're looking forward to that. We're going to have him at the law school, and I hope you'll have him on the show.
Well, I hope so. I'll have to.
He's a lot of fun.
I have to work slowly.
And he's been on national television very successfully. He's good on camera.
Yeah, he's got the turn of phrase. You know, I said to him one day, how do you prepare for this? You know, on television, you come up with these turns of phrases all the time, very catchy. They love that. Yeah. He says, I think about it all day long. I don't prepare specifically, but I'm walking down the street, I think about this stuff and build a little file. Right. Anyway, let's talk about tomorrow for a moment.
What's tomorrow, Jay?
Tomorrow's Thursday, actually. Thursday.
And what's happening at lunchtime?
Well, at lunchtime tomorrow, we're having something called Drones Over Hawaii, and what we can do about them. And it's got triple entendre anyway in there.
Right.
And it's sort of like the Supreme Court. I'm not sure which way it's going to go, but you're a speaker.
I am, and I hope I'm going last, and I hope to say a few things about constitutional law and ethics. But I've also noticed already that if you take the letters of drones and you rearrange them, you got snored. I hope nobody snores tomorrow.
Oh no, guarantee. It's really something for everybody, and I hate to use the word silos, but I worry about that. Because we have military
drones
strategy,
flying over the silos.
we have technology, who love the drones flying over the silos, and probably some discussion of UARC, the magic word UARC. Nobody wants to talk about that, but it's there.
We should say a little about what UARC is. People don't know.
University research something.
It's a Navy contract with the University of Hawaii.
Yes, and it's supposed to be for classified research, and we don't know, but it could be these very things that we're talking about, both in surveillance and of course in drones. And drones is subject to definition. What exactly is a drone? There are many different kinds of drones. Drones are principally civilian or military, but the technology is pretty much the same, except for the bombs. And all the deadly weapons.
And airspace could get very cluttered with these drones flying around.
Very interesting, and it's got to come up tomorrow, namely that the FAA refused to allow the State Department of Transportation to use a drone that it bought to patrol over the harbor because the harbor was too close to the airport. And so now it's an unused drone. What do you call that? And really, at the same time, the FAA is now considering making Hawaii a special demonstration place for drones.
And there are benign uses, for sure. Weather forecasting, looking at the shore and the health of reefs and so on, which can be best viewed from drones. But there's also a downside possible.
You could watch a Boston Sox game with a drone.
That's good.
Flying over.
That's good.
Thank you, Avi Soifer.
Great pleasure.
Thanks,
Jay.
on the show.
Take care.
We've only begun this discussion.
Tomorrow's going to be fun.
I wish there were more time, but we're out of time. That's Avi Soifer, the Dean of the William S. Richardson School of Law. Here on Wednesday at ThinkTech, we're talking about data surveillance, how now the Constitution. The conversation's only beginning. We'll be back with more in a little while. ThinkTech, Avi.
Got it.